During a trial here in New York, why does a judge tell the jury not to discuss the case amongst themselves during the course of breaks? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now at trial, whether it's an accident case or a medical malpractice case or even a wrongful death case, during the course of trial, the judge who is supervising and controlling the courtroom will tell the jury in every single instance, ladies and gentlemen of the jury, you are not to discuss this matter during the course of breaks and when you leave for the day. Now, why does he do that? He does that because the jury has not heard all of the information. The jury has not heard all of the testimony. The jury has not heard all of the legal arguments. And importantly, the jury has not heard the legal instructions that the judge will give them at the very end of the case. So the judge does not want them to start discussing amongst themselves what the different testimony means. Hey, what do you think about Dr. Jones? Hey, what do you think about this witness? Oh, because now they're going to get different impressions based upon their own initial gut feelings. The moment people start talking about their impressions, let's say you go to the movies, right? You walk out of the movie theater. The moment you walk out, your friend says, hey, what do you think of the movie? And now you tell them what you thought, and they may have a different impression. And now your impression may color their thinking when they tell you what it is that they've been thinking about. During the course of breaks, the jury goes back to the jury room, and they'll sit and chat with each other. But when the judge tells them, don't talk amongst yourselves about this case, it's because he does not want the jury to go ahead and get initial impressions from the different jurors, and each one chiming in about what they thought about a particular witness and a particular cross-examination question or a direct examination question or a piece of evidence. Why? Because they haven't heard everything yet. The judge tells them, hold your thoughts. Hold it until the very end of the case. And at the end of the case, when you've heard all the testimony, gotten all the evidence, and you get the instructions on the law, that's your time to go back to the jury room, begin deliberating, and now start exchanging ideas about who's right, who's wrong, and whether or not the injured victim has been able to show you that they are more likely right than wrong. That's why the judge in a civil case here in New York will tell the jurors, ladies and gentlemen, you are not to discuss this matter during the course of a break and when we are outside the courtroom. So why do I share this great information with you? I share it with you to give you an insight and an understanding into what goes on during the trial process here in the state of New York. You know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. I hope you have a remarkable day.